Well, I'll take it away now, and as
There
soon
you
as
go.
I'm able to share my screen, I will. Thank you, Jeff. Again, as Jeff mentioned, my name is Alan Schwartzseid. I am the managing partner for Kaye Rembaum's Orlando office. We have three other offices in Palm Beach Gardens, Pompano Beach, and Tampa. We also have an office in Miami by appointment. Bottom line, we operate throughout the state. I've personally got clients from our Orlando office anywhere between Perry, Florida, and Miami. So just understand if your community is located in Florida, it's one that we can help. We have 22 attorneys, all practicing exclusively in this area of law, except we also have one attorney who is board certified in construction law. So if you've got construction defects, we will handle the initial stages of trying to get those issues resolved. You don't have to immediately turn that over. We try to be not a one-stop shop for everything, but a one-stop shop for community associations, which is pretty much the only entities and people that we've represented since the 1990s for the most part. So if you've got any questions, if as a result of this seminar you're left with even more questions, which does tend to happen because I tend to point things out that people didn't think about, or if you just want to chat about any issues involving your community or maybe even how we can help you out, feel free to give me a call, shoot me an email. It's as@kbrlegal.com. This is in your materials. It's on this first page of the slides right here. You're also welcome to follow me on LinkedIn. That's where I generally post once a day, and you'll get either something about an upcoming seminar that I'm teaching, or just some helpful hints for attorneys, CAMs, and board members. So, with that said, we're happy to present this seminar for everyone's education today. But again, if your community ever needs legal representation, even if it's as kind of secondary counsel, we don't require any monthly minimums, annual fees, except for our specialized collection retainer program. So there are some communities that just want a second opinion, and you can hire us just for that in order to get that second opinion, or perhaps more importantly, with what I've heard is going on in the industry, to get a quicker opinion than you're able to get from your current counsel, because we do have a 1 business day turnaround time for at least acknowledging any communication we get from a client or potential client. So if you need to reach out to me, my email is here, and let's go ahead and actually get started in earnest on the material. So here's one of the most important things that you need to understand. The association, through its board, has the obligation to enforce what's in the declaration. You've got to enforce your covenants. You can't just ignore violations and hope they go away, because realistically, they won't. Okay, you can sit here and say, oh, yeah, we think that this person's going to resolve the issue. But the bottom line is, if you don't send them that demand letter that says you are violating our covenants, our restrictions, our rules, our regulations, guess what? They're not fixing that problem. Okay, so at least provide notice and then act on that notice. The most important thing I think you might learn today, if you don't already know it, is that avoiding most of the defenses to these types of lawsuits for covenant enforcement, meaning you're going after someone for violating your documents. The most important thing you can learn is to avoid those defenses by doing one thing: timely, consistent, uniform enforcement. That's one good thing that I learned from a previous employer. Not that our firm doesn't also practice that, but the bottom line is those three words are the most important words in the entire covenant enforcement realm. If you're doing timely enforcement, you don't have any of the time-based defenses. You don't have the statute of limitations where you've waited too long. You don't have a latches defense where someone says, well, I thought it was okay and I threw away all the documentation that would have defended this case because they waited so long to enforce it. If you do consistent and uniform enforcement, you don't have selective enforcement claims. You don't have estoppel and waiver claims. You're avoiding all of these defenses. So estoppel, just so you're aware, is basically, well, by your actions, I believe that I was allowed to do this. Waiver is, you told me you weren't going to do this, but you're enforcing it anyway. Latches, which is what I mentioned earlier, is the legal version of you snooze, you lose. If you sit on your rights for too long, they kind of go away. Now, there are specifics that need to go into a latches defense that we don't have the time to get into today. If that really is something you're curious about, there's a list of about 8 or 9 elements that someone needs to prove a latches defense from my perspective. So I'm happy to discuss this in more detail, but I don't want to waste everyone's time with it because, frankly, you just want the basics. You want to understand what we're doing here and how to do it the right way. So the right way to do it is to maintain the board's credibility through that timely, consistent, and uniform enforcement, making sure that you're avoiding those defenses and actively moving those enforcement matters forward. The easiest way to do that is to have an enforcement policy in place and follow it. That policy is generally going to say exactly what's going to happen when someone violates your covenants. So we'll get back into exactly what I think should go into that policy once we've gone through and I've explained a little bit more of that process, the enforcement process. Now, the other thing to keep in mind is this second point here. The directors owe a fiduciary duty to do what they reasonably believe to be in the best interest of the community. It's almost never going to be in the best interest of the community not to enforce your covenants unless there's some reason that they become unenforceable. Okay, because that does happen after certain amounts of time in an HOA if you don't do what you're supposed to do, which is to preserve those covenants in a recorded instrument. But the bottom line, that fiduciary duty is the highest duty that's imposed by Florida law. You're basically a trustee of the association. So when you ignore violations, there is the possible argument that you are violating that fiduciary duty by ignoring your legal obligations as a board member. Now, keep in mind, officer is different from director. Okay, if you're the president, that's not your capacity as a board member, but you still have obligations towards both positions, because chances are, if you're the president, you're also a director. Okay, the board of directors has this duty. So do all of the officers, by the way. So even if you're separate and distinct, one versus the other, director versus officer, you still owe that obligation to make sure you're doing what you reasonably believe to be in the best interest of the association. Now, keep in mind that breach of fiduciary duty is the subject of a lawsuit against the individual, not just the association. So one of the most important bills you will ever pay as a member of your association is your directors and officers liability insurance. Make sure you have that. Otherwise, frankly, from my perspective, the directors shouldn't be serving because they're taking on personal liability. The association might have some indemnification provision in its governing documents, but this insurance policy is really what's going to protect those individuals if they get sued in their individual capacities. So just make sure that you're doing what you really think is in the best interest of the association, which must include enforcing your covenants. If you're not enforcing your covenants, there are things that you can do to step back into good graces, so to speak, with that fiduciary duty. And we'll get into some of those options a little bit later in the presentation. Now, you might have some specific covenants, some restrictions that the board's responsible for enforcing. Those are going to include literally anything that it says in your governing documents that the owners must do. These might be architectural standards and alterations to the parcels being governed by a process of the members needing to submit some kind of approval. Keep in mind, if you have that architectural review procedure in place, you should also have separate and distinct architectural review standards. It'd basically be just a list of, here is what the association is going to allow its architectural review committee to say yay or nay based on. So it's going to contain the materials, the color wheel, all of your sizes, heights, locations, things like that. They need to be supported by what's in the declaration, but those architectural standards need to be clear and specific enough that someone would know what they are going to be allowed to do and not allowed to do before they submit that application. If it's not that clear, then your architectural review process, even if that application is denied, it might be that you're doing it wrong under Florida law. So just make sure that you're making those criteria clear enough and make sure that they're supported by the declaration, by the covenants themselves, which they're not enforceable unless they're supported by the declaration. So another suggestion, if you're going to adopt revisions or adopt your first set of architectural criteria, make sure to run it by your counsel before you do that. These are things that we look at on a daily basis within my office. Age restrictions in 55 and older, I think it's now referred to as 55 or better communities. Pet restrictions, keep in mind, we've also got a fair housing class that you might want to check out that I recently taught. It's on video, like Jeff mentioned, under our recordings in the education tab of our website, or resources tab, I'm sorry, of our website. Pet restrictions don't apply if you're talking about a service animal or an emotional support animal, but these are restrictions that might be in place. You also want to make sure that they're broad enough to encompass every circumstance you might want to address, but specific enough that they're clear that an owner knows, and in other words, a judge is going to understand and agree that this pet that they're bringing in, this pet tiger, is not allowed in the community, because you've not just said household pets, but you've specified these specific animals are allowed in the community. Restrictions on leasing and sales, these need to be specifically in the governing documents in the declaration, not just rules and regulations that the board has adopted. Guest and occupancy restrictions, same thing. Parking and vehicle restrictions, keep in mind, if you are going after parking on the street, you can only do that if you actually own the road. If the county or the city actually owns the streets in your community, that's the entity that needs to be going after parking violations. And they're not parking violations of your declaration. They're parking violations of the city code, the county code, whatever it may be. So just understand there is a limitation on a lot of what's in your declaration. Even if it's in there, it might not be enforceable. And then nuisance conduct we include because, frankly, it's one of the most difficult things for an association to actually prove. You need to show that there is a serious problem here, not just, well, one person was yelling one night and we're going to go ahead and enforce this nuisance. It's not really a nuisance in that case. Now, the enforcement action, this is where, like I said earlier, you send out your demand letter. That's the first step. You send out something that says, here's what you're doing wrong. Here's why it's wrong in our community. Here's what we think that you need to be doing to fix it. And here's the timeline within which we're going to provide to fix it. If you don't fix it within this amount of time, here is what the next step is. Now, I mentioned that next step should be dictated by a covenant enforcement policy. So here's step one in that policy. You send out your notice saying, hey, this is just a courtesy notice. We noticed that there's, a bunch of black spots on your gray driveway that's made of concrete. You need to clean those up. And, no problem. If you do it within the next 15 days, you won't hear from us again unless it happens again. That's your first courtesy notice. Okay. You're going to send maybe 2 or 3 of those in increasing aggressiveness. And if the owner, within that amount of time that you're providing in the covenant enforcement policy, doesn't cure the violation, then it's going to go to counsel. It's not just going to be, well, we sent our 3 notices. Now what? It's going to be, nope, we have a manager. It's the manager's job to send out these notices. The manager sent the notices without going back to the board. That's one of the most important parts of this covenant enforcement process. It's not the board decides to send a letter, because all that does is take longer to make the decision whether to send each letter. The manager's going to go out there, take a quick look at the property, see that the violation's there, see that it's still there in between each letter, and be automatically authorized to send that next letter. Okay, if you leave it up to the board, you are opening yourself up to risk, which as lawyers, we try to avoid. Okay, if you have it where it's an automated process and the only discretion that's provided is whether the manager thinks it's a violation or not, there's only one person who can screw this up. Okay, it's not the board that can screw it up. It's the manager that can say, well, I think it's a violation, and the owner argues that it's not. Then you send it to counsel for an opinion. If the owner doesn't respond or the owner doesn't comply with each one of these notices, you have it automated where the manager takes another look, they send the next letter, and you move along in the process. Okay. Again, when voluntary compliance isn't achieved within the period allotted, the offending conduct may become subject to mediation or formal action in court. That's the attorney process. But the first step is sending out this notice and saying, we're going to send 1, 2, or 3 notices before it reaches the attorney. And without thinking twice, without the board making a decision so that there's no delay, there's no, well, we don't want to spend the money to actually do something meaningful and send this to counsel, which is what I do hear, frankly, quite often is, well, we don't want to spend the money. And I'll talk about ways around some of that in a minute. If you're going to take the time to have your manager send out these letters, then you should be willing to take the next step and have it actually mean something that your manager sent out these letters. Okay, so you should be sending it to counsel, who will then send out either a courtesy notice or a final courtesy notice, or my preference is go straight to the offer for pre-suit mediation now that you've already sent 2 or 3 letters. Moving forward to fines, I don't like them. I'm going to say some other things, but the biggest thing I want you to know about fines is I don't like them. And it's not that I think they're a bad idea in theory. I think that there are some violations for which fines are appropriate. Most of them are going to be the dinky little violations, is what I like to call them. You didn't take your trash cans in on time. We're not going to file a lawsuit about that. Now, if it happens 5 times in a year, yeah, different story. You might consider pursuing a lawsuit about that, which is why your covenant enforcement policy is going to include fines for those types of violations. But it's also going to say that when you violate the same provision like this, that the board has decided we're not going to immediately send to counsel after those 3 notices. If you get 3 fines for the same type of violation within X amount of time, that becomes a nuisance, and that's what the association enforces through counsel. So you still get your 3 notices, it's just broken down over the course of a longer time frame, but instead of it just being fines, you're actually taking some real action to enforce the violation. And that's why I say I don't like fines, because I think they're a waste of time and they only kill the board's credibility. Fining does not cure the violation. It tells someone you owe me some money, pay me, and leave the violation outstanding. Nothing I can do about it. I'd rather see the association take real action and pursue these violations through an injunction, through self-help. We'll get into that in a minute. Through some other mechanism that actually resolves the violation. That's the big thing that I have a problem with. Fining doesn't cure the violation. It just tells someone they did something wrong, which, by the way, you've already done by sending your demand letter to cure the violation. Now, the other thing to keep in mind, or at least a couple things to keep in mind, fines can't exceed $100 per violation, or for ongoing violations, up to $1,000, unless your governing documents say otherwise. In a condo, you can't lien for fines at all. Doesn't matter what your documents say. What that means to me is you're guaranteeing that no one's ever going to file a lawsuit over that $1,000. You're not even going to go to small claims court over that. You're going to let it sit on the account until this person goes to sell the property, and either the fines are going to have expired by then because they're only good for 5 years if you don't collect them through a lawsuit, or you're probably going to waive them instead of trying to do anything to fight this and get them paid as part of the estoppel and closing process. Meaning, again, you're killing the board's credibility rather than making something actually happen. Now, the other thing to keep in mind, there is a lengthy process that the board needs to go through and the association needs to go through to levy these fines. I mentioned you can't have a lien for fines in a condo. You can in an HOA if the fine is $1,000 or more and your governing documents say that the fines can become a lien. Now, I've seen literally one client in 13 years in this industry actually file a lawsuit to pursue fines. It was as part of this exact situation, an HOA that had that provision in its documents that said fines become a lien, but they only were willing to do it because the owner, 2 owners actually, separately already owed assessments. So again, if you're not going to pursue this, why waste the time to levy the fines? Now, let's go through the process for fining real quick. And by the way, it's the same process for fining versus suspending use rights, which we'll also get into. Okay, a fine can't be levied unless the board has a meeting and decides to adopt the fines. After that board meeting, which requires 48 hours notice, the fining committee needs to be embodied in the first place. So good luck doing that. I'll explain that in a minute. Then they need to provide 14 days notice that there's going to be a hearing by the fining committee that the owner gets to attend and basically try and argue why the fine shouldn't be levied. Okay. This fining committee needs to be comprised of at least 3 people who are not on the board, not officers, not managers, not their family members. They are also generally the most hated people in the community because all they do for the association is levy fines because they're not allowed to do most of the other functions that you would associate with being important in the community. If you're able to embody this, that committee gets to decide whether the fines go through or not. If that fining committee decides, you know what, either they cured the violation within those 14 days between the board meeting and the hearing that we talked about, or we just don't think that the fine is appropriate. There's no fine. You've wasted your time. You've wasted 2 weeks of process where the violation just stays in place. And the owner didn't have to do anything other than come to the meeting and argue that they shouldn't be fined. Now, keep in mind, if that happens, you're probably going to, because the board gets to decide who is on this finding committee, the next step's probably going to be that the board says, well, if these people aren't going to vote for any of our fines, we're going to pull them off the finding committee and try and find 3 more people. But we can't fine until we appoint 3 more people to step into that role. If the fine is approved by the committee, it's due within 5 days after notice of the approved fine is sent to the owner. That's great. What happens when you send the notice of the fines and the owner doesn't pay them? Again, probably nothing. I've never seen an association sue based on fines alone. The only way I envision an association actually pursuing this is what I described earlier, where you've got a lien for it, or you're already filing an enforcement action and you just tack on another count for damages. And then you've got thousands of dollars to prove $100 to $1,000 in damages. Generally, communities choose not to go for that, and they just let it go. And again, all that does is kill the board's credibility. Just to be clear, it used to be that attorneys would argue, not me, but some attorneys would argue, you only needed to offer that meeting with 14 days notice. Now it's clear that meeting of the finding committee needs to actually be held. The statute was actually revised, I think it was this year in July of 23, to make it very clear you have to hold that meeting, not just offer it. And by the way, none of these meetings are closed. So you've got the owner basically whining and saying, don't fine me. And you've got these people on the committee either capitulating or, again, being the bad guy and actually fining the owner. Now, if you've got someone that's a true problem child, yeah, okay, maybe the members are happy with that finding committee. But again, that's not curing the violation. And I think it's a waste of time for most fines to be levied. Okay, we talked about this. The association, whether you're a condo or HOA, has the authority to fine. But again, the distinction here is if you're in an HOA and your docs provide for it, you can lien for fines. In a condo, that's not even a possibility. And again, in an HOA, it's only a fine of $1,000 or more per violation. Suspension of use rights and voting rights is another mechanism that the association can use to try and enforce the covenants. Now, you can suspend these use and voting rights generally if an owner is delinquent for, payment of charges that are owed to the association. That's a board decision. That doesn't require all of these notices that we talked about a minute ago. Okay, you can suspend these rights and they generally will pertain to amenities. You got to make sure that you're not restricting the owner's right to actually access their lot or their unit, any parking that is designated for them, or the ability to get in and out of the building, use elevators, things like that. It's not the basics, it's you don't get the amenities, you don't get the special benefits of being a member here. You can still use your lot, your unit exactly how you did before. It's just the things outside your unit, not, again, limited common elements, parking spaces are not things that you can take away. Okay, so basically the suspension gets approved by the board at a duly noticed board meeting. The suspension doesn't apply to parts of the common areas or common elements that are needed to access the property or to drive in and out of the community. And in the condo, suspensions can't include limited common elements, like I mentioned. In a condo, the other thing to keep in mind is that that monetary obligation needs to be at least $1,000, and you need to provide 30 days notice before you suspend voting rights. The other thing to keep in mind when it comes to suspending voting rights is that needs to be in the governing documents according to Florida case law. So if you can suspend use rights, which is again, the right to use those amenities, no matter what your governing documents say, unless they specifically say you can't. When it comes to suspending the right to vote at member meetings, that needs to be in your governing documents. It might be in your declaration, it might be in your bylaws. It's usually not going to be in your articles of incorporation. And if it's just in your rules and regulations, that is not good enough. So you got to amend if that's something that you want to use and it's not already in your documents. When you suspend the right for someone to vote, that vote no longer counts at all. So if you've got a community of 100 lots, 5 of those lots have had their rights suspended because they did something wrong, they didn't pay, whatever it is, and you've got this in your governing documents that you can suspend those rights. Now you have a pool of 95 owners and 95 voting interests to meet quorum requirements, get the approval for any changes that need to be made, etc. So that can be a blessing and a curse. Just keep that in mind. Now, obviously, you need to provide notice to the individual or to the lot and unit itself before these violations, or I'm sorry, before these suspensions will actually kick in. If you haven't provided notice, it doesn't matter that the board voted on it. You need to let them know you're not going to be allowed to use this anymore. Two major things that usually end up in the Q&A portion, so I'll address them now. Shutting off gate transponders, in my opinion, is not shutting off access to the community or to the lot. It's shutting off one method of access as long as you can go to the gate, call in, and be allowed in. It's shutting off key fobs and things like that I think is just fine. The other question I regularly get is, what about cable and internet? From my perspective, that's most likely a utility that you can't shut off. You can't shut off the electric, you can't shut off the water, you can't shut off the the cable. And especially if someone is paying separately for cable, the association 100% has no right to shut it off under Florida law. The other thing to keep in mind, if you are suspending for non-payment, that suspension can be kept in place until that entire debt is paid. So if someone owed you $50,000 in assessments, related charges, and other charges, and you notified them of that entire category of debt, and they paid $49,999.99, so they owe a penny, technically, the suspension can stay in place. Now, the statute says you can suspend these rights for a reasonable time. It's going to be up to a judge at some point to decide what amount of time is reasonable. So keep that in mind. But the bottom line is, from my perspective, if they still owe any money, including additional assessments that have accrued since this unpaid assessment started, sorry, but they're still suspended. Moving on, again, you need to give written notice. I talked about the De Soleil South Beach case, which is where if the declaration was recorded before the date of the amendment authorizing the suspensions, which was in 2010, and when I say suspensions, we're talking specifically about voting rights. So if your deck was recorded before 2010, the authority to suspend those voting rights needs to either be in the declaration, or you've got to have language called Kaufman language in your declaration that says that the statutes as amended from time to time are incorporated into your declaration. This is 100% a legal issue that your attorney should be giving an opinion on if you're curious as to whether you have these rights or not. Okay, we talked about all this. Suspension by covenant enforcement committee is the exact same thing we just talked about. The difference is what it's for and the process. So here, what it's for is one of the violations that we talked about earlier. You did something that was against the rules of your community, whether it's the covenants, the rules and regulations, whatever it may be. And as a result, we're going through this procedure to suspend your use or voting rights. The procedure is going to be exactly the same as it was for fining. So you're going to have a board meeting followed by a 14-day notice, a committee meeting of those same 3 individuals who are both fining committee and compliance committee, or whatever you want to call that committee. And once that committee decides that the suspension should be in place, that suspension kicks in once they provide notice. If the committee decides that the suspension should not occur, the suspension doesn't happen. And again, that is likely going to result in those people being pulled off the committee at the next board meeting. Moving forward, pre-suit resolution, dispute resolution, HOAs. There are a bunch of things that are subject to what's called pre-suit mediation. So this is another step in your covenant enforcement process. Okay, so you've gone through all of the letters that the association is going to send directly. If your attorney is going to send what I call, we refer to it as a courtesy notice. In reality, the way that I drafted is more of a nastygram, but it's kind of the, hey, we sent you 3 notices, we sent you 2 notices, you've done nothing to resolve the violation. Just understand that the next step is going to be to demand compliance and send a mediation demand. Okay, so the disputes that are subject to pre-suit mediation, I won't read them in detail, but just understand covenant enforcement is the last one here. anything that pertains to an improper use of the property or improper actions within the community is going to be subject to this pre-suit mediation process. Now, for those of you who don't know what mediation is, this is something I also do in addition to representing community associations. It's essentially someone, a mediator, steps in between the parties at a scheduled meeting and tries to get them, kind of shove them together so that where they've been butting heads, it's more of shoving them into a hug. And that hug doesn't have to be amicable, but it's the goal of mediation is to get the parties into a settlement that's mutually acceptable. Not agreeable, not great for the parties, but acceptable. To resolve this without the parties having to file a lawsuit, get an injunction, and get the court to enforce that injunction if it becomes necessary. Basically, it's an opportunity to avoid significant attorney's fees and costs by going through this process and having someone try and force the parties together to get this issue resolved. So again, there's a list here of items that are subject to this. Now, we talked about this covenant enforcement policy. Another issue that comes up is if your declaration provides for what's called self-help, then you might have the obligation to do that rather than file a lawsuit. So what self-help means is essentially you're stepping onto someone's property and curing a violation for them. Most declarations that allow for this will actually say that the cost of this self-help becomes an assessment against that individual lot. As a result of that provision, if it's in your declaration, for a long, long time, we were saying, well, you shouldn't be doing self-help because it's dangerous to go on someone's lot in Florida. And if you go onto someone's lot and either cause damage and they sue the association and the vendor, or you go on someone's lot and frankly, we're in Florida, the vendor gets shot or verbally or physically abused, we don't want the association being held responsible for that. Well, Florida courts have basically said, sorry, but that's not a good enough excuse not to use this remedy if you have it available in your governing documents, even if the remedy is an option and not something you have to do under your governing documents. So step one was a case that basically said, well, you know what? The association had the ability to force place homeowners insurance on this lot. The case is called Alorda. And the court in that case said that you shouldn't have been seeking an injunction, association, because you had what's called an adequate remedy at law. You had the ability to just go ahead and place the insurance and charge the cost to the owner as an assessment. Well, okay, I guess that makes sense. So a decade goes by, no one really thinks about Alorda, and if that's the situation where you're going to try and force place insurance, yeah, okay, in those specific circumstances, some communities would go ahead and force place the insurance and charge the cost to the owner. Now, I'm told recently that that's not even an option because the insurance carriers won't allow it anymore. But that is something that you might have the obligation to do. If you're not going to do anything that you're allowed to do when it comes to self-help, my suggestion is to amend your governing documents to remove it altogether, or at least remove those things that you're not going to do. Usually, well, you know what? Before I get into usually, let's go into Moriello, because that's the next meaningful case regarding self-help. In 2022, in April, this Moriello case comes out, and essentially the court said, well, the association had the ability under its governing documents to go onto someone's lot and trim the bushes, do the landscaping, weed the driveway, the sidewalk, and the apron, etc. Okay, fine. Now we got to do the insurance, and we have to weed, and we have to do all these landscaping violations if we've got self-help in our declaration. Fine. But we're not going to do any of the other stuff because it's just too risky. And then McConaughey comes out last year. The McConaughey court comes out and says, well, the risk of being shot in the face is too speculative to justify the association not trying this remedy if it's in their governing documents. Okay, I don't agree. I don't think that's speculation. I think it's a possibility and a distinct one. However, this is what the courts are telling us. And it is now precedent in Florida that if you have this right to do any self-help, even fixing the roof, going out and screening your water system next to the garage, which might cut utility lines, cut electrical lines, or whatever else, dig through a pipe. You never know what's under there. You still have to do it despite all those risks because they're too speculative, according to the Florida courts. So my suggestion is leave it to just the weeding, the mowing the lawn, the edging the lawn. Leave a carve out in your governing documents and amend out everything else that in reality you're never going to do. You're not going to go out onto someone's property and fix their roof. You're not going to power wash their siding and risk that you're going to blow right through it and they're going to have a hole in the side of their house. That's the association's alleged responsibility. Okay, amend out everything else. But just understand, this is a defense that an owner can raise if you try and go seek an injunction, which is what you're normally seeking in a covenant enforcement lawsuit, without trying self-help first. Now, if the owner writes back and says, if you come on my property, I'm going to shoot you in the face, or if you come on my property, I'll call the cops, to me, that's sufficient to justify attaching that as exhibit whatever to your complaint and saying they precluded us from doing self-help. That's why we're allowed to still go after our injunction. But beware, I mentioned that this is a defense. It's actually a complete defense that can wipe out the entire cause of action for the association if the association has the ability to do self-help and doesn't try to do it before you file your injunction lawsuit. So there are other causes of action we can help you pursue, but the bottom line is I'm actually using self-help for landscaping purposes as a way of saving my clients money by saying, if it's just weeds, go out and kill the weeds in the driveway. What's the biggest risk? That someone says they're allergic to the weed killer? Okay, then you tell them, all right, great. Now you've precluded me from going out and killing the weeds, and I can seek my injunction. But the bottom line is, I'm suggesting it as a cost-saving measure because I'd much rather see the association go out and, one, resolve the violation, meaning you don't need me anymore as of right now. You're not spending a couple $100s for me to send out a couple different letters for covenant enforcement. The process is done. You've already done the weeding. That violation's gone. Okay, two, you've got your cost of doing that is now potentially either an assessment against the lot or gets converted into an assessment against the lot at the next board meeting. That means that I'd rather see you send us a collection matter because someone didn't pay that new assessment, which is what this gets converted into, and you have an automatic right to recover your attorney's fees and costs in that collection matter, versus risking that you're going to spend $1,000, the owner cures the violation before you file your lawsuit, and you're completely out of luck on the fees and costs. Along the same lines, another suggestion that I'll make for an amendment that you might consider to your declaration is to make the cost of fees and costs incurred in enforcement an assessment against the lot that caused the enforcement. Meaning you're basically holding the individual or the lot or unit responsible that caused the violation. You're holding them responsible for paying the association's expense associated with the violation. Because keep in mind, otherwise, what you're really doing by not charging them that fee and that cost because you can't under your declaration, you're making every other member of the community responsible for it in addition to these people. You're spreading the wealth, but it's the opposite of wealth. Okay, I want these people that caused the problem to be responsible for curing it, resolving it, and paying the expense associated with it. So that's another amendment that I'm going to suggest if that's not already in your governing documents. And these are things that I work on a daily basis. I think between the self-help that I suggested, removing everything other than the ones that you're actually going to do, and this attorney's fees and costs as an assessment provision, I think I'm working on at least 5 of each one of those as of right now for various clients, because they are valuable. They bring this into a, well, this is what works best for the community, not just for this individual member. There are certain disputes going back to this general process that are not subject to pre-suit mediation. Okay, and the only one that I'm going to mention in detail is collection of an assessment, fine, or other financial obligation, including attorney's fees and costs due to the association. So when you send your demand letters, the pre-suit collection letters, because someone didn't pay their assessments, and you file your lawsuit and they try and defend that lawsuit, arguing you didn't go to pre-suit mediation, so this entire case is invalid and it needs to be dismissed, your response is, you'll excuse me, but BS. Okay, there's a statute that specifically says in condo and HOA world, this is not subject to pre-suit mediation. So go away. You didn't pay, you lose. Okay, there is a separate collection class we teach. I'm not going to go into detail on that, But that's the bottom line. That is not a defense to a collection action because it's specified in the statute that that's not subject to pre-suit mediation. Now, the condo provision and the condo procedure, when you get into the counsel level, so to speak, of this process, they're a little different. So what you're looking at here is three different options, and really only one of them is good in my opinion. What it used to be is that you could go to arbitration and it would be non-binding arbitration, meaning that someone that's not a judge and is hired by the state will decide your fate, and then you can enforce or appeal, pardon me, what that individual decided to a court. In other words, you're going through basically a mini lawsuit only to be able to file your lawsuit in order to enforce if they rule in your favor. That's non-binding arbitration. Binding arbitration is where that same person is going to make a decision and it is final. Okay. My problem with that is that the arbitrators that the state has hired aren't all very well versed in community association law. I'm not saying all of them are bad. I'm not saying none of them know what they're doing. There are some really good ones out there. But the problem that I have with them not necessarily knowing the case law, knowing what they're supposed to be ruling, is that they don't even have to follow precedent. There is case law that says that an arbitrator in these circumstances is entitled to be arbitrary in their decisions, meaning precedent doesn't mean anything to these people. Whereas if you're going to court, hopefully the judge cares about being appealed and is going to make the right decision according to Florida law. Meaning, if you walk into mediation, you don't succeed and you file your lawsuit, at least you've got some reasonable expectation of what's going to happen in this lawsuit. In arbitration, you don't necessarily have that expectation of what's going to happen because the arbitrator can decide whatever they want. The other problem I have with arbitration is that the arbitrators in Florida generally go by the attorney's fees that would have been reasonable about 20 years ago. They'll look at an attorney that's been practicing 20 years and say you're worth $225 an hour. Well, sorry, but that's not what most people that have been practicing that long would charge, especially when they literally wrote the book on the subject of covenant enforcement. I haven't been practicing for that long, but 15 years in, I literally wrote the book that the condo committee of the Florida Bar is going to publish on covenant enforcement for HOAs, wrote the defenses chapter for condos. You can't tell me that I'm only worth $225 an hour, but the arbitrators will do that anyway. What that means for the association is that you're left on the hook for $100 an hour, even when you win. And I don't like that. I think it's a bad idea. So bottom line, go through with the mediation process if you've got the option. Now, keep in mind, there are some things in Florida that have to go to arbitration rather than mediation. But covenant enforcement, the association, if you're the one filing in a condo, you still always have the choice between one and the other. And again, I would suggest you go to mediation. There are some things that are so egregious and so concerning that they're a health and safety concern. If that's the case, then the association can have the ability, and I would discuss this with your counsel rather than just presuming that it's the case, but you can go directly to court because it's an immediate issue. It's not a dispute under the statute, or it is so urgent that you need to file your temporary injunction lawsuit or the petition for temporary injunction immediately. There are other things listed here that are, again, just like in HOA world, they're not subject to pre-suit mediation in condo world. Here's another list. These are the mandatory arbitration with the division. This is the list of things that have to go to arbitration. And then here's one of the biggies in both condo and HOA disputes between parcel owners or between a parcel owner and a tenant. Unless the association's a party to that dispute, has nothing to do with the association and doesn't go to pre-suit mediation involving the association. That doesn't mean that the owner can't still send an offer for pre-suit mediation. It's just that it's not binding on the other owner to respond. Now, when I say binding, the important part here is you've got 20 days to respond to this letter, this offer to participate in pre-suit mediation, which is the first statutory notice that's actually required. You could technically skip everything I've described so far today and go straight to this letter if the board doesn't want to have a covenant enforcement procedure in place. The procedure could be, we send our statutory notice, you don't cure it or settle by then, we file our lawsuit. Have a nice day. That's totally up to the board. I suggest that you have some kind of procedure before then so that you can show a judge, we're trying to be reasonable here, judge. They're just not doing what they're supposed to do. So the offer to participate in pre-suit mediation, it's a letter that's sent. It's a statutory form letter, by the way. We fill in the blanks with respect to what the violation is, the names of the parties, the reason that it's a violation, the specific statutes and governing documents that it violates, and the specific provisions that it violates, etc. But it is it's a letter, the form for which is provided in the statute. It's sent via certified mail, return receipt requested. It's going to list with a copy via regular mail. It's going to list 5 mediators that the association is willing to use, and the owner needs to, within 20 days after that letter is sent, respond agreeing to mediation and agreeing to one of those 5 mediators. And if they don't within 20 days, the association can file its lawsuit. You don't have to go to mediation. Now, if the owner responds and says, yep, I'll agree to mediation, the association and the owner have 90 days to actually hold that mediation conference and try and get this resolved. If you can't hold that conference within 90 days and the parties agree to extend that time frame to try and get in the same room together or a Zoom meeting together, that's fine. But the association isn't obligated to provide more than that 90 days from the date that the letter was sent before filing its lawsuit. If there's no response, keep in mind the other important thing here is the owner waives their right to recover attorney's fees and costs. So this is definitely a letter you want to get right. You want it sent by your attorney. You don't want to be the one sending it out and then expecting the attorney to take over from there. You want to make sure this goes through counsel or that counsel is reviewing it. And frankly, it might be something that an attorney needs to send under the rules regulating the Florida bar. I don't know offhand, but I anticipate that if you are being that specific as to what the violation is and why it's a violation, that's a legal analysis that only a licensed attorney can make. If you go to mediation and you don't settle, same deal. You can go ahead and file your lawsuit whenever you want afterwards. The arbitration procedure is basically a little bit different. I explained it in very little detail, but it's essentially you file a petition, which is similar to a complaint that's filed in a lawsuit. It says what was done wrong, and what the association wants. And you're basically waiting for the party to respond to it, the owner to respond to it. There's supposed to be a hearing that takes place. And within 45 days after that hearing, the arbitrator is supposed to enter a final order. We're seeing shorter times on this, primarily because less people are using this provision in covenant enforcement, because mediation is now an option as of a couple of years ago. But it's still, I've rarely seen it happen within 45 days, and I've rarely seen the final hearing happen timely. And please understand, I'm not trying to bash the division or the arbitrators in particular. I think that they do a hard job, but I just wish that they actually adopted Florida law instead of going under their own banner, so to speak. When there's no settlement, a final order gets entered in the arbitration, and if the owner doesn't comply, again, you move forward to litigation just like you would after mediation. So I just think mediation is a quicker, cleaner 90-day process at most, and you're probably better served by trying to settle rather than immediately going to battle, which is what arbitration is. You're saying this is what the person did wrong, and if we don't get what we're asking for, it's not good enough. In mediation, it's, listen, we want you to do what you're supposed to do, but we're willing to compromise at least a little bit to get this resolved. Now, by the way, I haven't mentioned this, but I strongly believe the association should be trying to settle these things. It's not in the association's best interest to drag this out for as long as you can. It's in your best interest to enter an agreement that acknowledges the violation, meaning the owner's not going to defend it anymore. They're not going to say, well, I didn't do anything wrong. You're going to give them a specific time frame to cure the violation, specify what needs to be done and when. And if they don't comply, you're going to streamline your enforcement process. You're going to skip the pre-suit notice, the mediation, the arbitration. You're going to skip their defenses to any lawsuit about this. And you're basically going to be entitled to your judgment very quickly after you file that lawsuit if the owner doesn't comply. So it's not you should enter into a settlement agreement for the benefit of the owner. It's to keep the cost of enforcement and the timeline, for enforcement to an absolute minimum by having the owner agree to shorten those timelines as basically compensation for the association agreeing to hold off and keep the attorney's fees to a minimum, which also benefits the association. Now, some attorneys will tell you, I always start by saying the owner needs to pay the fees and costs you've incurred, whether the governing documents say so or not. But that's going to be up to the board whether to require that or not. Some communities see it as a cost of doing business to do the enforcement. Others will look at that and say, well, Alan suggested this amendment. I really think we should adopt it. And even if the owner doesn't comply and doesn't pay, we've got a right to assess the property instead of just being out the money. We talked about the self-help issues. Now, finally, let's move into some of the other limitations. I mentioned a few earlier, the FHA, ADA. This is the fair housing. So we talked about support animals, service animals. Keep in mind, these laws also govern any request for an accommodation due to a disability, and you really want to comply with those requests to the extent possible. So let's get into the policies, because I didn't say that earlier. We talked about the big five policies. One is the covenant enforcement policy, which is going to dictate your process for everything we've discussed from start to finish. We're going to send 2-3 letters. We're going to send it over to counsel. They're going to send a letter. They're going to send an offer for pre-suit mediation, and they're authorized immediately and automatically to file the lawsuit. And the manager is authorized to pay the cost deposit without a board meeting. Blah, 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 blah. You can include, like I said, the nuisance provision, which says if we're not going to go after this violation immediately, but if you do it a couple times within a short period, maybe 6 to 9 months, we're going to go ahead and treat that as an ongoing violation going forward, and we're going to enforce it via lawsuit if we need to. The next one is collection, unpaid assessments, unpaid charges. How are we going to collect? That's another one that should be automatic. The board shouldn't be making decisions as to whether or when you're going to go after the money that the association has budgeted for, which is what your assessments are, for the operation and maintenance of your community. Don't let owners sit there for 3 years not paying their assessments and not have a lien filed and a foreclosure action filed within those 3 years unless they're in bankruptcy or in mortgage foreclosure, and you can't or shouldn't move forward according to the board. The third one that I will suggest is a records inspection request policy. How do those need to be submitted? Do they need to be in a specific form? Generally, no. But, how are they submitted? What is the association going to do? What are the charges associated with responding to those records inspections? How is it going to be done? Is it going to be in person? Is it going to be some other method of producing the records, etc.? These are all things that we charge, a reasonable rate, I think, for preparing each one of these. And I do have some communities that come to me only to prepare these documents after pulling their governing documents. Number 4 is going to be member participation at meetings so that people can't hold up your meeting or frankly keep you from doing business by being a pain in the behind. And then finally, we talked about fair housing, ADA, a policy governing how the association is going to respond to those requests for accommodations and modifications of the community so that you don't get yourself in trouble. That one is not going to dictate how the owners behave. It's going to dictate how the board responds. So just understand, you can't require a specific form, specific language for those requests. It's just going to be something that you're basically outlining, hey, here's how we're going to deal with this to avoid violating these laws. The reason it's important to avoid violating these laws, in addition to what would normally you wouldn't want to violate the law, is that even if you win a lawsuit that someone files or a complaint that someone files with HUD, even if you win, you're generally not getting your attorney's fees and costs awarded, even if you were completely right, unless it is considered bad faith for them to have filed, meaning they had literally no reason whatsoever to believe that they were entitled to what they're asking for. I've literally never seen a judge find that that was filed in bad faith. It's always going to be, well, there was at least some reasonable basis for them to have believed that they were entitled to this accommodation. I've even seen some of these people say, well, they're elderly, so they thought they were entitled to it. That's not how it works under the law, but that was good enough to get them to well, elderly is close enough to disabled, apparently. Now, that's not me talking. That was the judge talking. But again, what you want to avoid is a $50,000 to $100,000 attorney's fee that you can't recover even if you win. So make sure to do it right the first time. The next one on this list is the over-the-air device rule. We're talking about basically satellite dishes and antennas and things like that. You generally have to allow those as long as they're not a certain size. I think it's 1 meter in diameter. But the association has to allow those. You can govern the location of these satellite dishes, preferably in a location that's not visible from outside the lot. but you can't govern in a way that will make this satellite dish or whatever it is less effective. So keep in mind, there are specific requirements. If you've got governing documents that say you can't have a satellite dish, just understand that's probably not enforceable. And if it specifically says it has to be in a certain location and that location won't function properly, probably not enforceable either. Same thing goes with solar collectors. We're talking about not only solar panels, which is probably how you would interpret that, but we're also talking about there's literally case law out there that even in a condo that maintained a roof, an owner was allowed to put a I can't think of the word right now, but it's basically a glass piece in the roof. And yes, I know it's absolutely absurd that I can't think of this word, but the owner was allowed to cut into the roof, put that piece of glass, sunlight. Good Lord. The owner was allowed to put a sunlight into the roof. And even though it wasn't their roof, it was the association's roof, the association can put reasonable limitations on this, require the owners to actually accept responsibility for any damage that's caused by these solar collectors, but you can't say just nope. And just like under OTARD, you can specify the location, but not if they're going to be less effective because of that location. There are certain laws also regarding flags. In an HOA, you're required to allow certain flags to be flown on the residence itself. Another two that need to be allowed potentially on a flagpole up to a certain height. These are generally going to be your state, federal, and first responder flags and a couple others. So just keep in mind, don't think that just because you have a flag restriction that you can say no. That applies in condos as well, so just be careful. Florida-friendly landscaping, no one seems to know what the hell this means, but the bottom line is you can't restrict landscaping that is beneficial for the environment. I have never seen a good definition of what this actually means or what is allowed and not allowed, but generally we're talking about xeriscape and things like that. And then finally, the last point I want to make today before we get into the Q&A, in an HOA, last year, the legislature screwed us up even worse by saying that anything that cannot be seen from the frontage of a lot or from an adjacent lot that is installed, stored, or maintained within the lot is not an enforceable violation. What this means is if someone wants to shove a whole bunch of pavers in the backyard and cover up their entire lawn, there's nothing the association can do about it unless you can see it from the frontage of the lot, meaning if this is the lot right here and I am the residence, the area right here. Okay, if you're looking at the street in front of the lot, looking at me, that's the frontage from wall to wall, from boundary to boundary. Now, some of the things to get around this terrible law that is unfortunately effective as of now, even though I think it's unconstitutional for the most part. If it's visible from an adjacent lot, it is something that can be enforced, meaning if you can look around or over a fence, maybe you can enforce it. If you can see this violation, this installation, whatever it might be, from a second-story window of an adjacent lot, like the chickens that live next to me, that shouldn't be there, although I think that they've gotten an emotional support thing from the city or the county. But generally speaking, you're not supposed to have chickens, okay? But if I can see them from my second-story window, that's an enforceable violation, barring an emotional support animal. You know, some of these things, the other thing to keep in mind is if you're across amenities, meaning, you know, I can see your lot from across the basketball court, or I am across a lake, across a golf course, that is not from an adjacent lot for purposes of the statute. Now, the final thing that I'll mention with respect to getting around this terrible law, which I think is completely idiotic and is not well thought out at all, but it is the law right now because someone wanted it to be. Because
How do you feel about it?
well, I mean, here's my problem. You've got communities. I represent a community that has been in existence for 50 years and has had the same restrictions in place for 50 years.
Yeah.
And all of a sudden, 50 years after everyone decided what the characteristics of this community were going to be, the legislature says, yeah, we don't really care what you thought 50 years ago when you first bought your lot. We're going to dictate that you can do whatever the hell you want in your backyard.
Yeah.
But I think that's a terrible idea.
Yeah.
But keep in mind when you do install those pavers over the grass, when your drainage goes to crap and all of a sudden you have problems with draining onto common areas, adjacent lots, and things of that nature. Now, all of a sudden, you've got a secondary violation that, regardless of this law, is enforceable in and of itself, because that is not the installation or storage that's an issue. Again, seeing a boat that's 12 feet tall over a 6-foot fence, it's still an enforceable violation. So I hope everyone got a lot out of this. We'll open it up to Q&A, but Jeff, I know you're going to want to do your thing before we get there. And I will move on just for temporary so that everyone has my information again. It's as@kbrlegal.com is the easiest way to reach me. Feel free to follow me on LinkedIn or reach out if you've got any questions. And now we've got 3. Todd asks, that was a lot to take in. Sorry if I missed this. If it was covered, I totally understand. That was an hour of blitzing, so no worries. Once a fine is levied, can that be added to their ledger as money owed and collect interest and late fees? The answer to that, Todd, depends whether the association's governing documents treat those fines as a lien and whether the lien or the fines itself exceed $1,000. If it's not $1,000 or more in an HOA, you can't lien for it, even if your governing documents say otherwise. In a condo, you can't add that to the ledger no matter what happens, no matter what your governing documents say. So again, we are looking at least $1,000 and a declaration or bylaws that specify that fines are treated as something that can be liened by the association. The other thing to keep in mind is that depending on how the governing documents are worded, you may need a separate board meeting after the fines are levied to convert them into an assessment. So this is something that I strongly suggest before you just tack this onto the ledger. Run that by your counsel and get a written opinion at least once as to whether this is something you're authorized to do. Because keep in mind, as you are sending out your demand letters for unpaid assessments, if you're including amounts that shouldn't be included, you're putting potentially yourself, your manager, and a bunch of other people that are sending out these notices in jeopardy, and at risk of being sued for fair debt violations, both statewide and federally. So strong recommendation, have your own counsel give an opinion on this because it is community specific and dollar amount specific. It's got to be at least $1,000. Moving forward to Mary, you mentioned 3 notices. However, state statutes only require a single 14-day notice, correct? If you're talking about fines, the board meeting needs to be noticed, and then you need to provide that 14-day notice of a fining committee meeting. That's only for fines. The notices that I'm talking about are notices that you just send saying, here's the violation, here's why it's a violation, here's what you need to do to cure it, and here's when you need to do it. Those 3 are not statutorily required. They're just something that I recommend so that you can show that the association was reasonable before you resorted to counsel. But you don't need to do that before you levy fines if you're going to go with fines, or if you're going to go with suspensions, which again, will generally, if it's for a violation rather than for an unpaid assessment or other charge, those suspensions are going to require that same board meeting followed by a 14-day notice and a committee meeting and then notice to the owner. So I hope that answered your question, Mary. Alexandra, good to see you. Potential fines were set up but not attached as an amendment to the covenants. Could they be fined? So your declaration doesn't need to provide for fines in order to levy fines. The problem is that in order to do anything to collect them, either as an assessment or otherwise, you need to at least know that they were properly passed. So I don't know if, based on what you're saying, it says they weren't attached as amendments to the covenants. That means you probably, I think from what I'm reading, you can't levy an assessment or a fine as an assessment. That doesn't mean you can't go after a damages claim for the fines, which again, I haven't seen any community association ever do in my experience of 13 years in this industry. Dan, can a condo change their declaration to give the condo more power over renters and a specific application that needs to be used for renters in the complex? Absolutely. However, keep in mind that that amendment to the declaration, which is what you're talking about, might only apply to the new owners that buy in after the amendment is recorded, and it may not apply to anyone who voted against that restriction until they sell their unit or their lot. Now, there are certain short-term rental provisions that'll apply across the board, but this is really one that the short answer is, can you change the deck and require these things? The short answer is absolutely yes, you can. The question is, does it apply across the board or only to certain owners that either voted in favor of it or bought in afterwards? Denny, if the HOA board's caught in selective enforcement to a member, should they apologize? No, the owner still violated the covenants. So from my perspective, no need to apologize, but you might consider not completing that enforcement process. So it really depends on the circumstances, but generally speaking, if an owner violates the covenants, the fact that someone else also happened to do wrong, it's literally two wrongs don't make a right except under the law. So that would be my answer to Denny. Michael, is it necessary to send 2 or 3 courtesy notices? Is email sufficient? It's not required to send any courtesy notices. It's just something that I suggest. My suggestion is also that your attorney send 1 notice before moving on with the statutory process. So not required. Email is sufficient as long as either you don't have a written policy governing covenant enforcement, or my recommendation, you have a policy that specifies we're going to send these notices via US mail and email, depending on what you want to do. Kelly, is installation of a fence in your backyard not visible from the front yard allowed if the documents state the committee must approve first? That committee is still going to have the authority to approve or reject. The only thing is, if it's rejected and you install it anyway, the committee, the association might not have an enforcement mechanism because it is something installed in your backyard. Now, I'd be surprised if that fence is not visible from an adjacent lot, but that's up to you to take the risk. Joanne, should a POA continue enforcing deed restrictions deemed unenforceable by an attorney opinion? Probably not, unless there is some reason that the board believes it is enforceable. In that case, I would suggest that they bring those reasons back to the attorney or get a second opinion rather than just doing what they've been told is not allowed. The problem with doing something that you've been told by an attorney is not allowed is that you no longer have the benefit of what's called the business judgment rule, meaning you're not relying on advice of counsel. You're in fact violating advice of counsel at that point. So again, if you think that the attorney was wrong, get a second opinion either from the attorney or from another attorney. And that is something that we routinely do, is give a second opinion about certain issues. And frankly, 3 times in the last month, I've had that result in clients that realized, oh, maybe we should be working with KBR for all of our legal needs. So yes, you can get a second opinion. And yes, you probably should in the instance that Joanne's talking about. Eileen, do all our rules and regs need to be in our declaration or bylaws to be enforceable? The answer is no, but they can't contradict what's in your declaration or bylaws. They need to be supported by and not contradict any of those 2 documents. And they need to be reasonable in accordance with whatever Florida law says, or frankly, what a judge decides if the rule is being enforced and is being interpreted for the first time. T. Straub, the language regarding election crimes specifically states election. What is your opinion as to why it wouldn't include all voting? We experienced voting fraud regarding election recall. It's not on topic, but my suggestion is take that up with the legislature. I have a feeling that the reason for that is that there is a specific legislator or small group of legislators that has a big problem with the less than 1% of voter fraud that's occurring throughout the state, and decided to make it a statutory issue that wasn't necessary, in my opinion. And by the way, that was already either civilly or criminally penalized. So that's why I say it wasn't necessary. The board created a rule, same T. Straub, owners can't have any communication with any vendor. I agree with cannot direct vendors' work. Many owners use HOA vendors to replace for their own driveways. Our board is violating and finding is this overreach. If it has absolutely nothing to do with the association's business and it's not interfering with the vendor while they're trying to do business for the association, yes, it might be overreach. Jimmy, good to see you here. For covenant enforcement issues, which may be difficult to resolve via self-help measures, such as parking violations, what's the recommended course of action for the association? Towing, perhaps? Well, thank you for answering your own question. Feel free to reach out if we can help with that, because yes, your next step is going to be to enact a towing policy and put up signage and start towing vehicles that are parked in violation of your restrictions. Again, keep in mind what I mentioned earlier. You can only do that. You can only enforce restrictions pertaining to parking if the association actually maintains and owns the roads. So if you're not the owner of those roads and it's city or county, you got to get the city or county to do the towing. Let's see. Okay, we've answered that. And M. Robbins, if your house is being repainted the same color, do you still need an ARC? You need to look at your governing documents to answer that. Some of them say specifically that you do. My opinion is if you're using the exact same color in your governing documents and your rules and regs, your architectural criteria don't specify, you probably don't need that approval. Let's see, moving on. Last one we've got right now. T. Straub, our board is violating and finding on rules they pass at board meetings, but are never communicated to all owners and are not included in the rules posted on the website. The board is still violating and finding when owners really have no way to know. Well, I mean, the board should be notifying the members of what the rules and regulations are if they want them to comply with those rules and regulations. And from my perspective, an appropriate response from an owner might be, I had no notice that these rules and regulations were adopted. Generally speaking, the association is obligated to give at least 14 days notice and put a notice and have an agenda item that says that this is adoption of rules and regulations governing parcel use. If the association didn't do that, those rules and regulations might not be enforceable. But again, it's more of a case-by-case analysis of what the board did and didn't do. So I see that Jeff closed down the Q&A. We've gotten through all the questions for the first time in my career at KBR. And I don't know whether I should be excited about that or upset that you guys didn't have more questions, but I'll go through my brief thank you very much for everyone who attended. I see that most of the people that showed up are actually still here. I really appreciate that. And if you need anything, if your community needs counsel, if you're not getting responses from your current counsel, or if you just have a question you need answered, feel free to reach out to me, as@KBR Legal, and I'll KBRlegal.com.